Hey everybody, welcome to True Crime Wednesday. Sorry I missed everybody on Friday, but it was for a very good reason. I was in LA helping my daughter do wedding planning stuff and had a blast in LA. It was nice to get out of the Idaho weather for a little while, but I'm back home, as you can see, and we will be this weekend conquering more quilt blocks now that I'm back on track. But you can see our True Crime Quilt Guild. I never get that figured out. Our True Crime Quilt Guild quilt blocks are up there, and we are going to set up a Facebook group so that y'all can post your pictures of your own squares. Welcome. I'm Lori Hellis, for those of you who haven't been with us before, and welcome to True Crime Wednesday. We have a bit to talk about. Wednesday's the day that we talk about a variety of cases, and I usually like to sort of chat for a little while and kind of bring everybody up to date, and then open the evening up for questions. So let's get right into it. I had a great question from Barbara Kay about how, kind of a general question about how lawyers use case law and how you pick a case to use in, say, a motion or a brief. So what happens is the lawyers are looking for cases that are close to their fact pattern and on their subject matter. So for instance, in a case where you have in a situation where you have I just wanted to make sure my microphone was working. In the situation where you have a case that you are working on, that you would, sorry, I have dogs barking. In a situation where you have sorry, trying to organize my microphone and deal with the dog barking. In a situation where, like the Vallow case, where you have a specific fact pattern, such as the case being delayed because of Lori's questions about her competence, you would be looking for cases that have a similar theme, or delay the case for some similar reason. And you'd be looking for a case that is considered to be routinely cited as interpreting the law, and one that is referenced frequently. You're also going to be making sure that the case that you're referencing hasn't been overturned, because that can happen too. So usually you're looking for a case that most closely resembles your case, so resembles your fact pattern, and then looking for a good case that very clearly outlines the law and the steps. So sometimes the court will say, this is the analysis. We have to look at this first, and then this, and then this. And so it often is the court outlining an analysis based on the statute. So that was a great question, though, and I figured if Barbara was asking, there probably were other people who would be curious as well. The big news in the Vallow Daybell case is that the judge denied Lori's motion to dismiss the case because of speedy trial issues. That I was not surprised at. I expected that the judge was going to deny it. I thought that his reasoning was very cogent and made a great deal of sense. He went through the analysis that is generally accepted in the case law, both at the federal and the state level. And based on that analysis, he determined that he was denying her motion. So as far as we know, trial is going to go forward on April 3rd, and we'll charge forward. However, there are a flurry of motions going on, not unusual at this point in a case, but there's a flurry and a little flood of motions going on right now. A lot of it having to do with discovery. Now, I thought it was interesting that during the last hearing on Thursday, one of the things that John Pryor said was they had all met at in Ada County here in Boise at the courthouse here in preparation for trial. So they're beginning to figure out the logistics of how this highly publicized case is going to go, and logistics of picking juries and all of those issues. And I thought it was really interesting that John Pryor said at that meeting, the prosecution gave him 5 more files of information, including 1,188 pages of GPS information from the FBI. This is not new information. This is information that should have come to the defense 2 years ago. This is information that was used by the CAST team in order to identify where Alex's phone was and whether it was in Chad Daybell's backyard. So it seems to me that this is a big deal. It is really improper for the defense to be, or the prosecution to be dropping new evidence, new discovery on the defense at this point. That is getting really close to sandbagging. The defense should be preparing their trial and working with their witnesses and doing all of that background kind of information. They should not be trying to digest new discovery this close to trial. So much as you may think that sometimes John Pryor can be annoying or that he's whining, he is right on this case. That is a problem in itself, because John Pryor may have an argument for severing this case. That's a problem. If you recall, back at the hearing that happened in late January or mid-January, the judge denied his last motion to continue the case, but said, I could be convinced to sever these cases. He denied the continuance, saying that Lori's speedy trial rights took precedent over Pryor's lack of time to prepare. But he said he could be convinced to sever the cases if it appeared that there was discovery, that potentially exculpatory discovery, that could be that was being delayed. So now we get to this point and we have all of this GPS information that Pryor's had to have an expert review. So what happens if the cell phone information proves that Chad wasn't anywhere around his house when Tammy died? Well, that's clearly exculpatory information, and the defense should have had it a long time ago. I think we're bordering on discovery violations that could justify the judge severing the trials. It's very troubling. It's very bothersome that the prosecution has not been on the up and up, and it's disturbing. It makes one wonder, are they trying to keep this information from the defense, or are they simply so inexperienced that with even with 4 lawyers working on the case, they still have not been able to get their act together? It's discouraging. But we're going to have to wait to see what the judge does with this information. That brings me to a couple of new filings, and they're things that we're not entirely clear on yet because I don't have copies yet. The way it works is that when something is filed by the court, it doesn't always hit the court database the day it's filed. Sometimes takes a day or two, particularly if it's over a weekend. Then we have the issue of we have to get copies, and those copies have to come from Fremont County. So we have a system set up where we request those copies for anything that shows up on the docket and that isn't sealed. But there are a lot of things that are not sealed, but don't end up on the statewide cases of interest list of documents that you can actually pull a PDF of. So as soon as we have these new documents, I will be commenting on them. One of them is a motion to dismiss the indictment again. I don't know on what basis it's being filed, but it was filed by Chad's attorney, John Pryor. So I suspect it may have something to do with the discovery violations, but I don't know at this point. So it will be it'll be important to see those documents. We don't know yet. The other motions that were filed have an awful lot to do with discovery and with whether or not the discovery was timely. And so we're going to have to wait to see what happens with those motions. There are motions, there is a motion hearing that was set for Friday that has been postponed. And the interesting thing about that is it's a sealed motion. We're not really sure what is going on, but they're asking for some evidentiary rulings ahead of time, which would be motions in limine, having to do with 404B evidence. And for those of you who remember, 404B comes up a lot. It came up a lot in the Murdaugh case, and there's more to talk about with that. But the 404B information is character evidence, evidence of a person's character or their propensity for committing crime or their propensity for violence. So in the Vallow case, I suspect what they're trying to keep out is Charles Vallow's death and Lori's involvement in that. And so we'll have to wait to see whether that's what the judge is ruling on and what his ruling will be. So let's, I have a couple of other small, not small cases, but little bits to impart about big cases. And then we'll move into Murdaugh because there's so much to talk about on Murdaugh. In the Brian Kohberger case, there have been quite a few reports that he was let go from his teaching assistant job right before or after the murders. That is unsubstantiated, and there's some indication that that may have been fake. Somebody had created a fake document. So it's undetermined at this point. I think that there's so little information coming out about the Kohberger case right now because we're in this lull until we have his preliminary hearing in June. We're not hearing much of anything, and I think there's a lot sort of flooding in to fill that vacuum. So be cautious when you are looking at information on the internet. It gets us all sometimes, but there's quite a dispute. Some of the better known stations are claiming it is factual and other people are claiming that it is not. So it's always good to be cautious about what we are sharing and what we are continuing to put out there for everyone. I had a request to talk a bit about the Bridigan case. That's the case of I think he was a Microsoft executive. And I am going to do some research on that case, and we will be talking about it as time goes on, but I haven't gotten myself up to speed because I've been thoroughly immersed in Murdaugh. The other case of interest that I'm sure we will be talking about because it is a significant case, and also another case that has to do with filicide, with a parent killing a child, and that is Lindsay Clenny. Lindsay Clenny was arrested and charged with murdering her 3 children before attempting suicide herself. It appears to be a case similar to Andrea Yates. It appears to be a case that involves postpartum psychosis, which is a severe form of postpartum depression. And so, but we don't really know enough yet. It was very interesting. She's been in the hospital. She was very seriously injured when she jumped out of a second story window. She has a spinal injury. It's very unlikely that she'll ever walk again, that she'll be wheelchair ridden for the rest of her life. And there was a bail hearing. And I thought it was very interesting because the judge did take into consideration her mental illness and her physical condition. The prosecutors just wanted her sent to the hospital that takes care of prisoners, the prison ward at the hospital, basically. And the judge declined to do that. The judge allowed her to remain in the hospital where she was, and also allowed for a provision for her to be moved to a mental health facility once she's released from the hospital. I don't know how much of that had to do with the fact that the judge sort of thought she's probably not a huge threat to herself, since she is at this point requires round-the-clock care and round-the-clock physical assistance. So it's not like she's going to bolt out and commit a violent crime right away. I don't know, but that appears to be the judge's thinking in permitting her to go to a mental health facility. Wow. And then we have Murdaugh. I know that a lot of you have been watching Murdaugh and have a lot of questions, so I'm not going to spend a lot of time recapping the trial, because I know that everybody's got a lot of questions about what has happened in the trial. It has been absolutely riveting, and at the same time, really hard to watch. The medical examiner's testimony was very hard. I mean, I cannot, it was difficult to listen to, even as a person who has listened to medical examiners before, seen autopsy reports before, dealt with these kind of cases before. It was unpleasant and unsettling. I cannot imagine what it must have been like for the family members to be there and to hear some of that information. So I don't know how the family is doing. I don't know. I hope that that they're all getting lots of mental health counseling and lots of support, because that was a very difficult presentation. Interestingly enough, for those of you who are familiar with the story, after Alec Murdaugh was confronted by his law firm, and after Maggie and Paul died, then the law firm finally got all of the documents together. This was in September, all of the documents together, and had a complete picture of all of the money that he had anyway. Sorry, just something caught my eye in the chat. I need to stop doing that, because I have the world's best moderators and they can take care of those things. Anyway, During that September timeframe, the law firm finally put together and discovered how much money that Alec Murdaugh had stolen, and confronted him and told him he was finished at the firm. He then tried to come up with some excuses and some compromises and finally resigned. Shortly after that day, he was shot along the road. He claimed at the time that he was changing a tire when a complete stranger pulled up behind him and shot him, making it appear that there was somebody out, bad guys were out to get the whole family, that the bad guys who had gotten Maggie and Paul were back. That very quickly imploded, and law enforcement very quickly realized that that story didn't hold any water. He then admitted that he had cousin Eddie, they call him, Eddie Smith, who was Curtis Eddie Smith, who is a distant cousin of Alex, attempt to shoot him by the side of the road in order to let his son Buster collect the $10 or $12 million in life insurance that he had and that he believed would not cover if he committed suicide himself. He then was shipped off to a rehab facility for his opiate addiction. And so that became just another chapter of Alec lying, Alec looking for sympathy, Alec trying to divert attention from his misdeeds. So initially, when earlier today, Maggie's sister testified, and the issue of that roadside incident came up. And the judge ruled that bringing in that testimony would be more prejudicial than probative, and the judge ruled for the defense to keep it out. But apparently later today, because I have not gotten all the way through today's court testimony, apparently late this afternoon, the judge reversed his ruling, saying that the defense had in fact opened the door on that testimony. So now we don't know what's going to happen tomorrow, but it is possible that the state could put on Curtis Eddie Smith. One of the unusual pieces, or the pieces that is unexplained, is the fact that, for those of you who are following the case, all of the financial misdeeds came in, including the fact that there was a settlement of a very big case against Mack Trucks. And Alec's portion of that, of the attorney fees in that case, came up to $792,000. He told the other lawyer, Chris Smith, anyway, that he would be investing those fees to create an income annuity for Maggie. And in fact, what he was doing was misappropriating them. He told the other attorney who was distributing the fees that his firm knew and had agreed that he could do this annuity with the fees. In fact, his firm, PMPED, knew nothing about that. And it wasn't until much later that they discovered the diversion of the fees. But $500,000 of that $792,000 ended up in cousin Eddie's pocket. No one knows why. So Curtis Eddie Smith ended up with $500,000 of that money. Then Alec, when the law firm got wise to what had happened, he scrambled around and borrowed money in order to put all that money back into Chris Wilson's um, trust account before before he would get found out. So it looks like Curtis Eddie Smith's testimony is going to come in, and that will be interesting because we don't know where that money went. We don't know where any of it, all that millions of dollars went. We don't know why he paid Curtis Eddie Smith that money. So that will be interesting. I think at this point we will go ahead and open it up for questions and move forward through the questions, because I know that all of you who have been watching the Murdaugh case probably have lots of questions about what's been going on there. So post your questions. Please start out with the word questions so that we can catch them quickly. Our mods can grab them. And hi, Janet. Yes, they said 50,000 a week for drugs, and it is a ludicrous amount of money for pills. Even at its worst, oxycodone pills usually are between $10 and $20 each, and people who are addicted often use as many as 10 or 15 a day. Even at that, you are not getting to the $50,000 level. The only way you're getting to $50,000 is if you're handing them out like candy to everybody. So the idea that he had a $50,000 a week drug habit is absurd. And no one has been able to figure out how we make the connection between I'm a drug addict to I had to steal all this money. Nobody's been able to figure that part out yet. Bo Peep, how are you? This is a good question. And I will say that this is a function of white privilege. I know that that's might not be a popular answer, but the Murdaugh family were 4 generations of wealth and power. And when they call Alec's mother Miss Libby, okay, very respectful, and so I believe that this is the same reason that they didn't do a very in-depth search at Moselle. They didn't do a very, very in-depth, they didn't tape off and search Alec's mom's house right away because they were deferential, because that was a rich and powerful family. She's a little old lady with Alzheimer's, and they were deferring to her and to the Murdaugh family in not disturbing their frail matriarch with a home search. It was wrong. It was they certainly should have searched her house right away. The same, they should have searched Moselle right away. But let's remember that the day that the murders happened, 4 or 5 members of Alec's law firm descended on the property. And everywhere that law enforcement went, there was a lawyer hovering over their shoulder. So you add that to the fact that there was that the Murdaughs had this reputation of being this very powerful and very well-connected family. And you've got law enforcement officers who are going to defer, and they're going to be deferential, and they're going to be probably more respectful than they should have been. That we didn't have law enforcement going in there pulling up the drains and swabbing all of his shoes and they didn't do those things because there were too many damn lawyers breathing down their necks. And I think this is exactly the reason why they didn't tape off and search his mother's house. I think if they had, they would have found more evidence that he was later able to hide. But that we have to understand now. I am a West Coast girl, and the West Coast functions very differently than the East Coast and the South. And there are very different social norms, very different social niceties that I may not really understand. But do understand that these were Southern gentlemen. That was Miss Libby's house. They weren't going to go in there and disrupt the frail matriarch of the Murdaugh family, because there was just too much on the line, too many influential people. Today, in fact, we heard I don't know whether it's the second or the third interview that they did with Alec. His friend Corey Fleming, who has since been disbarred, was also there with him, attorney, and they're going through that whole discussion of where he was and what he was doing. And in spite of the fact that toward the end of the interview, the officer asked him outright, "Did you murder your wife and your son?" Just in spite of that, he's still polite, deferential, friendly. And there's definitely less of a confrontational sort of style even, than there would be in other parts of the country. So it's interesting. The reels. Tinsley said he is still making money. His name is still on the roster. I'm not sure who you're talking about, whether you're talking about Corey Fleming or whether you're talking about Alec Murdaugh. So the reels help clarify that. Because my understanding, the way it works, when Tinsley was on the stand, he was talking about the fact that during the time that he was trying to get Alec to settle the boat case, Alec was still practicing and still had a lot of cases on the court roster. And so what would happen is, and this is a common practice in a lot of jurisdictions, where you have a court hearing at a particular time during the week, and it's a pretrial hearing where all of the lawyers who have cases that are on the docket for the next week go, and the judge determines which cases are going to go on what priority, which judge is going to hear what case. And so I think what Tinsley was saying was that during that time when he was prosecuting the boat case and trying to get Alec to settle the boat case, and Alec was saying he was broke, Tinsley was saying, I'm going to those meetings and 60% of the cases are all Alec's cases. So he was still at that point making money. He certainly would not be able to make money after he was disbarred. Now, there may still be money owed to him from his firm from prior to his being disbarred. But once he was disbarred, he couldn't continue to get money from practicing law. So everything that he would be entitled to would have to have been before he was disbarred. Kathleen Smith. In Chad's, we're over to the Vallow case now. In Chad's preliminary hearing, the cast FBI guy testified about Alex Cox's cell phone pinging on Chad's property. didn't the prosecution present that discovery to the defense at that time? I think that's a really good question. I think they presented the part of that GPS data that they analyzed out of Alex's phone that pinpointed his locations in Chad's backyard. But apparently, they did not provide all of the GPS data that they extracted out of the phones. So you probably, if you're following the Murdaugh case, have gotten a little lesson in the extraction process for cell phones. So not all, when the information is extracted out of a cell phone, it's not in a particularly usable form. It has to be manipulated into a form that we can understand. So my understanding is that the cast and FBI folks, the cast folks analyzed what they needed, the portion of the information they needed in order to pinpoint Alex's movements. But I don't think by any means that was all of the GPS information. So, and it may just be inexperience on the part of the prosecution, because they didn't go back to the FBI and say, give me everything you've got. They assumed they had everything. Yeah. KCL. Do I think, based on what's been presented so far, that Alex is guilty? And do the defense arguments resonate with me? I think that the prosecution has put together a very good circumstantial case. They have shown how all the little pieces of this puzzle connect to prove beyond a reasonable doubt that Alec is guilty. I definitely think that they have shown that there was adequate time for him to have committed the murders, and that he had the means. Certainly, he had the means to commit the crimes, and the state has put on a pretty good argument for why he had a motive. You have to remember that murder is irrational. It's an irrational act. So trying to explain to a rational person why a person would react irrationally, including commit murder, is a little bit difficult sometimes. So I do understand that it's hard sometimes to convince a jury. Now, we don't need motive. They don't have to prove motive, but it certainly helps the jury understand why the murders happened. And I'm not sure they have cemented that piece of it yet. I think they have proven that he had the mechanism, the means, the ability, the understanding, all of those things. I think that they are right on the very edge of connecting up all the dots. The senior investigator who was on today, that was his job: connect the dots, connect the timeline. So I think they're really on the verge of doing that. There are some defense arguments that do resonate with me. I do think that their job has been to poke holes in this circumstantial case. If you think of circumstantial case as a bunch of links in a chain that have to be connected up together, then their job is to disconnect those chains, is to delink that chain and to put holes in it, so that the jury's not getting a full picture of this connected line of occurrences that then culminate in the murders. I don't know that they have done enough to poke enough holes in the circumstantial case to make it happen. But there are some of their arguments that certainly do resonate with me. And I have some real questions about whether or not um, uh, Cousin Eddie helps anybody. That will be really interesting to see uh, what the jury makes of that and whether or not he testifies. There's been some buzz about the possibility of Alec taking the stand. That would be very unusual, but we've seen it before. We saw it with Jodi Arias. So it'll be interesting to see whether he decides that he's the best person to tell the story or not. Mary Sarah. After the murders, did Tinsley drop Alex from his case on the boat case? I don't believe he did. He dropped Paul, but I don't believe he dropped Alec. I believe that Alec is still a defendant on the case. Tinsley did say that he was prepared to drop Alec off the boat case because victims are very sympathetic. And he felt that if, in fact, Alec's family had been murdered by some sort of outside force, that Alec would be very sympathetic, and that it would impede them getting a judgment. So there was just there was consideration after the boat crash to by Tinsley to dropping Alec from the case, but I don't believe he was dropped from the case because I think it kind of became quickly evident that law enforcement was focusing on Alec as the primary suspect in the murders, and that certainly wouldn't hurt his case going forward. Do you think the jury will buy the dog keeper's testimony about the hose being left twisted after he had taken care of the dogs that afternoon? I thought his testimony was interesting, and I thought that it helped the jury to see the possibility that somebody else was down there at the kennels and that somebody cleaned up. I thought that it helped them see that, in fact, this guy always put the hose away a certain way, and that when law enforcement got there, the hose was not the way that he left it. It might have been a little less persuasive had this guy not been so exacting about the way that he took care and treated that hose. But he was, and so he was able to say, this is the way that I always do things. And it was evident at the scene that somebody had taken that hose down. Who knows? It could have been Maggie. She could have gone down there and decided that the kennels weren't clean enough and she wanted them hosed out. Who knows? But it does sort of plant that little seed of, what was he washing off? Well, did he wash himself off after he was spattered with blood? And we know he changed his clothes. Where did the bloody clothes go? Well, we don't know. The same place the guns went. So, yeah, I think it certainly added a layer of gee whiz, and a layer of the jury being able to say, well, one more thing that's inconsistent in Alec's story about what happened that night. What are my thoughts on Poot's shenanigans? I know I was calling Pooty. I think it's interesting. I found his stuff to be a little surprising sometimes. I found it a little surprising that he has been less aggressive than I expected. I'm so tired of him bumbling. I mean, he does the Columbo bumbling routine, and I'm sick of that. But it is interesting. I expected that he was really going to go after Mark Tinsley, and he didn't. He actually deferred that to one of the other lawyers and didn't go after Mark Tinsley. I thought that was interesting because I kind of expected he was going to be the one to, really go head to head with Mark Tinsley. Yeah, and he's very arrogant. He's very I didn't like at all the way that he treated the female medical examiner. I thought that he would not have treated a male medical examiner in that same way. Just the way he talked to her, he was very dismissive. He was, come down here. He never said, would you mind coming down here and giving me a hand, or any of the other niceties that I think he would have had had the medical examiner been male. But he certainly was kind of short and ordered her around and kind of made fun of her a little bit. And I found that kind of offensive. But I think that's his style. I think he's arrogant, and he's a state senator. He has a lot of power. He has a lot of influence, and I think he just feels like he can get away with things that maybe other people wouldn't get away with. Although I will say that I think Judge Newman has been very fair and a very good judge. He has been right on top of it all the way along, and I admire him tremendously. I thought his ruling about Curtis Eddie Smith and then opening the door, that was very interesting, and I am anxious to actually hear that that part. I think that I think it has probably been a very long time since Dick Harpootlian has tried a 3 or 4 week case, and I think he's exhausted. I think he's really tired. Um, these long cases are absolutely exhausting. Remember that the lawyers are sitting at the counsel table. They are trying to make sure all their documents are in the right place, that they've got their exhibits lined up, that they've offered them into evidence, and make sure that they're into the court record, and all the time they've got a client sitting next to them who's writing them notes frantically, and they're trying to listen to testimony at the same time and they hear something in the testimony and think, oh, where's that exhibit that I can use to prove that that's not right? And it's constant. And a week-long trial is a lot. It's exhausting because not only are you in court all day, but then you have to go home and digest what happened all day. And that means you've got 4 or 5 more hours of work and reorganizing your exhibits and maybe rethinking your cross-examination for the next day. All those things are waiting for you when you get out of trial. And they've been doing that now for 3.5 weeks. It's exhausting. And Pootie's not a young guy, and I think he's getting really tired. I think they're all getting tired. I think the jury's getting tired too. I was listening to Gigi McKelvey, who is in the courtroom. She is on for not News Nation, Law and Crime. Sorry, don't want to put her someplace where she isn't. She has been helping out with Anjanette Levy on Law and Crime, and she's been in the courtroom. her observation was that she felt the jury was getting tired. They're getting weary. 2 people have been released because they had COVID. So there's the threat of COVID continuing on, um, uh, with, sorry, I just saw something in chat I wanted to point out. Michelle, who is our one of our 2 mods, had a little bit of a family emergency and had to go pick a family member up at the ER. Nothing serious, but a few stitches were required. So she is headed out, but we still have Brenda with us. Yay. Thank you, Brenda. And so we'll just move on through the questions. So I think everybody's getting very tired in this trial, and we still haven't seen the defense's case yet. So we're in for a couple more weeks. That girl James. Thoughts about the professionalism or lack of by both sides. Seems a lot of missed opportunities to object, and the judge has said over and over, no speaking objections, but they both continue. Well, you know, judges, every judge has their own style, and every judge handles things differently. There have been a lot of uh, objections by the defense to the prosecutor's kind of leading question style. And Judge Newman's always, he says the same thing every time, don't lead the witness. And then they rephrase the question and get around the issue of it being leading. Creighton Waters seems to have that kind of conversational style that borders on leading questions. And so that raises a lot of those kinds of objections. I think both sides have been pretty professional. I think they both have been have been. There are lawyers who will object simply to throw the other lawyer off their stride. There are lawyers who will just objection, 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 just to throw the other lawyer off their game. I don't really see that happening here. And I do see that in most cases, I think the objections are there's a basis for them. I won't say there's that they're well brought, but at least there's a reasonable basis in the rules of evidence for them to object. So I actually have felt like it's been a pretty well conducted trial on both sides. Now we haven't seen the defense's case, so we don't know. But with the exception of Harpootlian being a little bit demeaning when it comes to questioning women on the stand in general and the medical examiner in particular, I think it's been a pretty clean trial. And I'm immensely impressed with Judge Newman. So good questions, everybody. Um, I'm going to pop this one up while we're talking, since I just saw this one. Judge Newman called out one of the prosecutors on having a personal conversation with the witnesses. It's that one prosecutor, I don't know his name. He's a big guy. He's the one who kind of wanders around the courtroom, gets too far away from the microphone, and he does do that kind of leaning on the witness stand, showing them something, touching their arm. And I agree. I absolutely agree. There should be no physical contact with a witness. And I have also noticed that prosecutor tends to do that when there are women on the stand. And I think that is very inappropriate. So I would agree that is, it's personal style. I kind of would guess he's of the sort of good old boy age and maybe feels like that's endearing or that's, that puts the witness at ease. I personally don't think it does, and I think it's objectionable. So I agree that that is that's not appropriate. I'm just helping Michelle out here since, or not Michelle, Brenda out here since Michelle had to run. But let's see. Well, we answered that one. So let's grab this one. Have I noticed the absence of Brother Randy in the courtroom? Yeah, I mean, I know that John Marvin has been there. I know that Buster has been there. I know that some of the other family members have been there. I think John Marvin's wife. But I completely understand. First of all, Randy is a lawyer in the law firm, and I'm certain that he's got other duties than sitting in his brother's trial all day. So there's that part of it. And I think that it is very, I think it's a really personal decision because I think it is going to be I think it would be very difficult to sit in the court and listen to the stuff that he's had to hear going on about what his brother his brother has done. So I can't really say whether that's a noticeable absence or not, but I do notice that that he has not been there. It drives me crazy every time does a prosecuting lawyer stroll around the room and continues to touch witnesses and get in their personal space. Yeah, I agree. Although in a complex trial like this, I think it is important that the lawyers be able to move around the room. There's a lot of moving parts going on. There's exhibits and there's stuff to go on screens and there's computer stuff. And so it would be difficult for them to remain seated during that whole time. So moving around the courtroom, being able to offer exhibits, moving around the courtroom, putting stuff up on the screen, I think those are all appropriate things. But I do agree that that particular lawyer spends a lot of time getting into people's personal space, especially the women who are on the stand. Let's see, other question. In all these big cases, is a lot of talk of the jurors' rules, no discussions, no media, etc. I've wondered, are the teams of lawyers given these same instructions? No, not at all. And well, I will say that the ethical rules of professional responsibility require that lawyers not try their cases in the media and that they not seek out media coverage of their cases. It also there also may be a gag order. I don't know for sure. But if there isn't a gag order, then the lawyers in the case would be free to talk to and discuss the case as long as it fell within those professional rules of professional responsibility. I think most lawyers, once a trial starts, are not going to have any conversations outside of the courtroom with media. I haven't seen anybody doing that. And but of course, they're discussing the case among themselves and between the defense and the prosecution. There are conversations going on all the time and every night after court. So what happened to the boat case? As far as I know, it is still pending. Rachel, hello, Lori. I have a technical question. I'm surprised by how much interaction there is between the two sides. Why do the lawyers walk over to the other desk and ask questions or show papers? Good question. So anytime you are going to offer an exhibit in your case, so the prosecution has offered something somewhere around 500 plus exhibits. Some are digital exhibits, most are on paper. So anytime that you are going to offer an exhibit, you have to take a copy of that over to the other side and ask them whether or not they have any objection. And you have to be able to present that, even if they have all of that stuff in front of them. It's just a formality in the court. So the lawyer who's asking the court to admit it has to take it over, make sure that the other side has seen it and understands which piece of paper he's talking about, and then has to ask, are there any objections? If not, then, Your Honor, we'd offer exhibit 500. The other side says no objection, and the judge says it's admitted. But that formality has to happen. So they are walking over to the other side and asking questions and showing them exhibits to make sure that everybody's on the same exhibit at the same time. When there are hundreds of exhibits, things can get pretty mixed up pretty quickly. So it's just sort of another check to say, I'm offering this picture of today. It was a picture of the interview room that the police interviewed Alec in. And, I'm offering this picture and taking it over and giving it and showing it to the defense and saying, this is exhibit 500. Okay, well, no objection. So that is kind of part of the process. Ahead of time, I am certain that there has been a lot of discussion between the defense and the prosecution about which exhibits are going to come in. There's no surprises. Everybody's got all that discovery. And so there have been conversations about how to keep the trial moving by, maybe streamlining the process to get all those exhibits in. Murdaugh. Harpootlian is an absolute asshat. His condescension toward the Satterfield son was utterly disgusting, hoping it resurfaces by his opponent during next election. Well, I will agree that I didn't feel that he was particularly respectful of Tony Satterfield. I think that once again, Tony Satterfield is the son of the Murdaugh housekeeper. She died in an accident at Moselle as a result of an accident at Moselle. And he made the point in his testimony that the other brother is developmentally disabled. Tony Satterfield is not an educated, sophisticated person. And I think that although I don't believe that Harpootlian was attempting to take advantage of that, I think that he was dismissive and condescending, and I think that's just the way he is. I think he's part of that OG old boys generation where they could get away with behaving like that. And I agree that it was unpleasant and disgusting to watch him do that. I don't know where he stands with his constituency, so I don't know whether he's much beloved and will easily be reelected or not. Mary, does Griffin have a conflict of interest since he was close to the family and had even communicated with witnesses before the trial, as in Marion Proctor, that is Maggie's sister and brother-in-law? I I don't think it's particularly a conflict of interest because he was communicating with Marion really on behalf of his representation of Alec. He was talking to witnesses about the case at hand. There's no indication that he has any kind of an adverse position or that he would represent somebody who has an adverse position to the Proctors and their family. It is not unusual for lawyers to have conversations with witnesses ahead of trial, and you have heard of several different witnesses who've said, yes, I talked to you 2 weeks ago, or we met last week, or so it's not unusual for lawyers to meet with witnesses, to prepare witnesses for trial, to explain, here's what I'm going to be asking you, and go over, the witness's statement ahead of time. So I don't think it's a conflict of interest. I think that it's clear that Griffin had a relationship with the Murdaugh family and knew them, or was in, I don't know how much of a relationship it was and how much of it was just simply that they ran in the same social circles. So I think that's pretty common down there. The generations, they all know one another for 2 or 3 generations back. One of the law enforcement officers said that he realized that somebody was a cousin of somebody else. So, it's a small community, and a very socially stratified community. So people don't sort of move in between their social levels easily. So you get the same families and the same people in the same circles. Yeah, it's different. How can the defense possibly explain the video taken in the kennels? Oh, I think this is the silver bullet, really. This is the key to the whole case. When Alec told everybody I was never at the kennels, I didn't know they were there, and when he told his whole story, and even when he gave his second and third interview to law enforcement, they had still not cracked Paul's phone, and they still did not know that video was there. So at that point, all they had was Paul's friend Rogan saying, hey, I talked to Paul about my dog, and he was down at the kennels, and I would have sworn I heard Alec's voice, but they were not, they did not have that evidence until much later when they cracked Paul's phone. So the video was really the kiss of death. That is going to be very difficult to get around. When you line it up on the timeline with everything else, with the data from his car, with the data from the phones, with the information knowing that Maggie and Paul's phones literally locked for the last time within minutes, 3 minutes or so of that video being shot. So that's very hard to explain. It's really hard to poke holes in that kind of timing technology, and that kind of evidence about how close that timing was. And then you add on top of it all the other places where Alec Murdaugh lied or tried to get other people to lie. I was at my mom's house for 40 minutes instead of 20, wasn't I? Wink, wink. I was wearing this shirt that night, wasn't I? Wink, wink. Those kinds of things. So I think that the video is probably the linchpin to all of that other circumstantial evidence. I think that kind of sits in the circle, and then all these other things kind of come off of it. It will be really interesting to see what the jury does with that information. Yeah, Judge Newman did call out one of the prosecutors for having a personal conversation, and I agree completely. They should not touch the witnesses. And I, I personally never liked it when people tried to touch me, and I tried really hard not to do that to other people. I thought that it was unprofessional and disrespectful, and so I do agree that they didn't really have any business doing that. I think one of the things that Judge Newman didn't like was the fact that he was kind of leaning over the witness stand longer than he needed to be, that it was difficult because he was far away from a microphone, and there was really no need for him to be standing there. He was just still standing there. And, it looked more like they were having a conversation over the fence than, a testimony. So, let's see. We're a little over an hour. So I think we'll take if anybody's got any other questions, we'll take a couple more, but I think he is, I think we've begun to wrap our arms around the Murdaugh case. Thank you so much, Hazelnut, for your generous donation. I noticed a few others that came up, and I want to say thanks to everybody who sent us a super chat tonight. As you all know, any super chats that come in go directly to our mods, and they are very grateful for those donations. If you have not liked and subscribed, please do. It helps us with the algorithm, and it also means that you'll get notifications when we put up new content or go live unexpectedly. And as we get closer to the Vallow case, we may have a few more unexpected lives. Once the trial starts, I guarantee that I will be in the courtroom, and I will be going live with YouTube Shorts and with short videos on Facebook and probably on Instagram as well, to keep everyone up to date on what's going on in the courtroom day by day, and maybe even hour by hour. I think I'll also be trying to live tweet a bit, so following on Twitter might be important too. Carrie Gans, let's take this last question and then we'll say goodnight. Can I address the gag order in the Kohberger case? To silence the victim's family and strip them of their constitutional rights seems not only unethical, but unconstitutional. I agree wholeheartedly. I think that the judge has entirely overstepped her authority. His, that's Judge, I think. I think the judge has entirely overstepped his authority in this regard. There is absolutely no basis for gagging the families. I understand that there are a couple of family members that are very vocal and are very quick to call law enforcement and the judicial system to account. That's what the First Amendment is for. The First Amendment is to allow us to question our government and to make sure that oversight is happening and that the light of day is shining into these processes. And I agree wholeheartedly that this judge had no business gagging the family. I don't believe that he has the authority or the jurisdiction to do it. And I believe that the Idaho Supreme Court, as conservative as they are, will overturn the gag order if they can just get it in front of the court. I cannot see any way that it is constitutional to gag a private citizen, essentially. The judge doesn't have any authority over a private citizen. So I absolutely agree with you. I think that it will be overturned at some point, although it's hard to say at this point how soon they may get it in front of a higher court. So I want to say thanks to everybody for joining us tonight. I know that there are many things that you could be doing with your Wednesday night, and I'm grateful that you're spending it with us. I want to thank everybody for their support and kind words when we weren't here on Friday. I'm trying really hard not to miss our lives because I love doing them. But occasionally we have to make room for other things. I had a wonderful time with my daughter. I wish I could post pictures, but we're not there yet because we don't want to ruin the surprise for everybody. But I'm excited. This is going to be a lovely event, and we are very excited for her new life. I want to thank everybody for joining us tonight. Thanks again for super chats. And I'm going to say goodnight, and we will see you all on Wednesday or on Friday. Sorry. I hope by that time we will have those new documents from the Vallow case and be able to give you a little bit more insight on why it is that John Pryor is asking to dismiss the indictment. We're going after those documents, so we'll be able to explain that next time. So until then, have a great week, and we'll see you for TGIF. Good night.